Thank you so much for the breaking news update, Deanna. This is definitely a shock to me. I'm sure it'll be interesting for a lot of business owners. And so, as always, I always appreciate your time and your expertise when it comes to employment law. And so just as a quick breaking news update, we can kind of jump right in. As always, as a disclaimer, this is not to be used as legal advice. Just kind of as a notification of some changes that we need to make people aware of, and kind of help companies prepare as best as possible. There's probably going to be a lot of questions and some special individual circumstances. And if you have any questions, please make sure to reach out to Griffin Resources or Ogletree Deakins, and Deanna, contact information will be displayed at the end of this as well as in the comments. So the biggest change that we are seeing is I definitely have a lot of questions on the Texas federal court and what that means, the federal ruling of the Department of Labor. And a lot of what we had talked about in the past and helped companies prepare for was the change in salary limitations for being considered exempt for salary versus hourly. And there was an increase that happened in July and was also happening in January. So can you describe what happened in the courts and what kind of power this has now?
Sure, absolutely. So kind of taking this back a few steps, this case has been pending in federal court in Texas for some time. If you are familiar with kind of challenges to past government regulations, you may have started to pick up on the fact that almost all of these cases are in federal court in Texas. And that is on purpose. Typically, these business groups will forum shop in a way and try to pick a court that is more conservative and more favorable to businesses and employers from the get-go, which is probably why we saw this case filed in Texas. Initially, the plaintiffs were asking for an injunction nationwide from the beginning at the preliminary stage of the case. And the court declined to enter that injunction nationwide, but actually did issue an injunction when it came to the state of Texas itself. However, there was a lot of foreshadowing in that initial opinion on the preliminary injunction, stating that likely the agency had exceeded its statutory authority in issuing this rule. And then ultimately, the court had committed to coming up with a decision before the new threshold on January 1st. So just to recap, in case you're not familiar with this increase, it was a two-step increase with an increase on July 1st and then a second increase on January 1st. So obviously we're past July 1st. Also since July, we've had a shakeup at the Supreme Court level when it comes to the agency's authority to implement and interpret rules. It used to be Chevron deference was the legal term of art, meaning that courts would defer to the judgment of administrative agencies in the areas that they're tasked with enforcing. We had a new case called Loper Bright that overturned that and basically said, no, courts no longer have to give this broad deference to administrative agencies. So it didn't look good for the Department of Labor here, both because the court had already said, we think you've exceeded your authority in its preliminary opinion on the injunction, even though that wasn't nationwide. And then we have this new Supreme Court case that says, okay, agencies, we're not just going to let you have this broad, unfettered discretion that you may have had in the past. So the injunction now that has just been put into place is nationwide. So the rule is blocked nationwide. Even if you're not in Texas, this rule is no longer going to apply to you. What is interesting is the court said that pretty much three core pieces of this rule were all invalid and exceeded the agency's authority. So the July 1 salary levels, the January 1 salary levels, and this automatic increase that was built in to raise the minimum salary level every 3 years. So pretty much all of that has gone away. So if you weren't sure whether or not you could benefit from this injunction, you can. Now, I know a lot of employers, and we even had a discussion like this one, Michelle, for the July increase and what you might want to do. And I know a lot of employers already did go ahead and raise some salaries or potentially reclassify some employees because the July 1st deadline has come and gone. Is that your understanding as well, Michelle?
Yeah, we helped a lot of companies do some audits on their overhead and their salaries to understand who would have been affected on July 1st and help them make changes. Some people went ahead and just gave the increase in salary. So if they were already properly classified as exempt, which means they didn't get overtime. So we wanted to make sure that those people continued to get their annual salary. And so that's what we saw happen most often is people getting those pay increases up to that level. Most companies only increased to the July 1. Some went ahead and did it as far as the January 1 numbers so that they wouldn't have to do it again. And then others reclassified. So if they didn't or couldn't afford those kinds of salary increases, we saw them reclassifying them to hourly. And if this hadn't changed, we believe they would have continued to be properly classified, without the salary changes. So this kind of goes into some of the other questions about actions that companies have now. So if they've increased salaries, to turn around and take that away would be devastating, I think, to the employees. It would change morale. But technically, I guess legally, companies can change salaries in reverse, I assume.
You can, as long as you follow any kind of state-specific notice requirements before you make that change. And I would say probably the majority of states, as long as you give that notice within a pay period prior to when it's going to take effect, you're generally going to be covered. But some states like California may have more aggressive rules than that. I think the main thing, and this is part of what the court had really focused on in issuing the nationwide injunction, is it said this basically just made this a salary rule, and it really disregarded the job duties test, which is the second piece of this that you have to meet in order to properly classify an employee as exempt. So you have to pay them the minimum salary, which is what we've been talking about. And they also have to meet the job duties test for the category of exemption that you're using. So I think it's important not to forget about that, right? And I think that's what a lot of employers did when the July 1st deadline was looming, was what you said, Michelle. They did an audit of their positions and said, okay, let's look at anybody that's going to be below the July 1 salary minimum and make sure that they meet the duties and then decide, right? Because sometimes things change, sometimes roles change, sometimes someone's not doing a certain piece of their job that they had been doing in the past, particularly if you hadn't looked at your jobs since the pandemic. So I think it was a good time for employers to take a hard look at these jobs and really decide, do they meet the duties test, and are we going to be okay if the salary minimum is raised? Now, the prior salary threshold of $35,000, that is not a lot in today's market, right? So if you had folks that were just meeting that, I mean, I think, again, it's a time to take a hard look at those job duties and make sure that they were properly classified. And I think the same goes now, okay? Like Michelle said, it's hard to roll back a salary increase, but I know some companies might have said, we're just gonna make those folks non-exempt. If you did that, you could make them exempt again, as long as—
That was going to be my next question, was if you did change them and everything does hold true, the rollback to the previous salary and the duties test audit does still also hold. And if you just change them back to exempt, then essentially, I assume you would just pick a date to do that if there was a change date. So any kind of overtime or earned rates up through when they were non-exempt would have an effective date. Is there a notification where you have to kind of explain the same thing to the person? Obviously, like, I guess before the next pay period or something like that, or what's the recommendation there?
Yes, I would say at a minimum, you would want to do one pay period. Since we're going through the holidays and we're almost to the end of the year, I know some clients are thinking about, if they made someone non-exempt, letting them know, okay, as of January 1, we're going to put you back into your exempt category. And just also explaining that the reason for this is because there is a pending government regulation and the company does its best to comply with those rules and laws as they change. So that was the reason for the change. Now we've had another change and we're just basically trying to put it right to where you were before. And sometimes, there are pros and cons with that. I think some employees view exempt status as being like a higher level status, whether that's true in practice or not. But overtime is obviously attractive, but if you're really not working that much overtime anyway, some employees might welcome that change back to exempt because they don't have to track their time and they have a little bit more flexibility.
There's a note in our slide here that talks about specific requirements, specifically in a handful of states. And you had mentioned this before about kind of making some changes on a state-by-state basis. Is there, and I know California probably more than I know some of the other states, where they have different wage requirements in those states that are different than the federal Fair Labor Standards Act numbers. So if they're in these states, or I guess any other states, there's probably some review they need to go through just to make sure that even though the Fair Labor Standards Act is rolled back, there's some states that on the state level, they could have different regulations, I guess, under their own department. I don't know who would regulate on the state side, a Department of Labor or some kind of similar Labor Act. And how do they make sure to look that up? Or is there easiest ways is to contact, someone like you or myself to kind of help them do that research? And what does that, I guess, mean for them if they are in that state level and make a change that is not correct for their state? What happens then?
That's a great point to raise, that there are a handful of states, and we have them here: Alaska, California, Colorado, Maine, New York, and Washington, that have their own salary minimums to classify an employee as exempt. And honestly, like, if you're not in these states right now, you're going to be under that Fair Labor Standards Act threshold that we've been talking about. But just keep watching this. This is a new area that we've seen kind of explode over the past year or two. Before, we hadn't seen states doing this and setting their own minimum salary thresholds for exempt status. But if we don't see the federal rule replaced with something that may be a little bit more reasonable or something else, this is something that we might see other states jump in and do and say, okay, 35,000 is just not enough. So since the federal government hasn't acted, we're going to go ahead and act and implement a requirement for our own state. Typically, we're seeing that in states that have their own state-run departments of labor. Like in Florida, where we sit, we don't have a state Department of Labor. We just follow the federal Department of Labor. But states that have their own, it's kind of easier to get these things implemented. But that doesn't mean that there couldn't also be a state law that's legislated that says, hey, it's going to be a new statute within our state that you have to have a certain salary minimum. And another area, since we're talking about it so similar, is a lot of states have started to say you have to have a certain salary minimum for non-compete agreements to be enforceable, right? And interestingly enough, these salary thresholds sometimes are the same in these states like California to be exempt, and then also to be able to have an enforceable non-compete. So if you use non-competes, non-solicits, just be aware that that's another area where minimum salaries can become important.
And that was also something that was under review recently, where there was a bunch of laws, or I guess lawsuits, happening in relation to that. Just real briefly, what happened with those lawsuits? I think there was supposed to be where it was making non-competes null and void, which I believe finalized as completely being overruled as well. Did that land and settle down?
So that was also at the federal level with the Federal Trade Commission that was trying to implement for the first time a ban on non-competes at the federal level. So they did lose the case. They have filed an appeal, but whether that will continue on when we have President Trump take office for his second term, I think it's unlikely that that's going to be something that's on the agenda to aggressively pursue that. We may see the FTC drop the case, or maybe even try to resolve it with some type of settlement that involves them withdrawing that rule, at least in its current form. And we'll just kind of wait and see if they attempt to do something else. But I think this is another area where, in the absence of the federal government being able to get a rule in place, that more and more states might have a minimum salary threshold for non-competes. So it's just something to kind of watch out for. And I think that's the theme we're going to see a lot as far as President Trump's second term. And looking to President Trump's first term, he was very much about like less enforcement, less regulations, fewer regulations. If you're going to enact a new regulation, you have to repeal an old regulation or two, et cetera. So if that theme continues with his second term, we could see more enforcement at the state level instead of the federal level.
Okay. And then just as recommendations for this, as we kind of wrap this up, we have a note on here that having a documentation for the reasoning of any kind of salary adjustments or changes or even exemption changes that you make. Most companies obviously may put like a memo in writing or do something for the employee, but how far should this documentation go? Should companies put things as like just a decision memo or something in their own filing system for any kind of changes that they're making? Especially if they did some kind of mass audit and looked at everyone's salaries, and that also incorporated into decisions for several people that were impacted. I assume documenting that in the reverse would be wise. And how does that documentation help companies when they do that kind of documentation?
Yeah, so great question there. And thinking about too how you did your audit, right? So if you worked with legal counsel at all during the audit phase, you may benefit from the attorney-client, attorney work product privileges, so that none of that information would be discoverable if a lawsuit is filed by an employee challenging their exempt status or saying that they have improperly had a salary reduction. If not, you just want to be careful about how you document it, right? So you don't have to put every thought into that documentation. What you're looking for is some kind of core rationale for this is the legitimate business reason why we adjusted these positions to be exempt to non-exempt or non-exempt to exempt. We reviewed the job duties test, determined that it meets it, or we didn't even look at the job duties. We were simply focused on the salary minimum because that is what was going to change with this new law that has since been stopped, right? So if that's what you focused on and you were just trying to comply with the new minimum and that was the scope of your audit, that's okay. You just want to be straightforward with that. Where might you see problems and where this would become helpful? Let's say that you ended up having some employees that were made non-exempt, right? And now they've been paid overtime. Let's say they're making more now than they had been in the past because they're getting this overtime. And then they're unhappy because you want to reclassify them as exempt now because you can. If all of those folks, let's say, end up being in a protected category, they're all female, they're all over 40, they're all a certain race, right? They might say, ooh, we think we're being targeted because of this protected category. And you would want to be able to say, no, it didn't have anything to do with that. It was just purely based on us trying to comply with this rule that since went away. And we determined that they still meet the job duties test. And with the new salary minimum not happening, we've properly reclassified them as exempt. Of course, consistency is key with things like that. We want to make sure that we're treating people within the same roles consistently.
Okay. And just kind of our last slide here has our contact information on it to reach out to Griffin Resources or to Ogletree directly, to Deanna or myself. And we can definitely help anyone walk through any of these challenges and decisions. And as Deanna mentioned, having that attorney-client privilege really does help when you're, having to deal with some of these decisions, and how that can help you in the long run when it comes to preparing for any kind of documentation that you might need that can help the company. Just be prepared for any cases that may come forward, and just prepare in a very logical and documentation way, and treat everyone fairly and consistently. So these are all very tough decisions for companies to make, and especially if they've were trying to do the right thing by these employees, and now they've got to kind of roll back some of those decisions, especially for financial decisions for the company, because some of these salaries were a little bit difficult for companies to make, and then now they can obviously it's going to impact their employees for changes in the future. One last question that I just thought of was, is there a time frame for any of this to make these changes? So if they wait until the new year or anything like that and still say it was about this law, or is there any kind of a timeline where if it's several months away where it's too late to tie it back, or is that kind of making a difference for them?
That's a good question. So there's no automatic deadline kind of built into this injunction process or anything like that. But I think the further that you get away from this decision being changed, the harder it's going to be to sell that that's the trigger for your decision, right? So I think, even if you're going to make the effective date a little bit down the road, if you can go ahead and make the decision sooner rather than later, it's going to be helpful. And I would be reluctant to go beyond like a 2 or 3 month window. I think it might look speculative if you go beyond that.
Well, thank you so much for your time. Really appreciate it. And we'll definitely make sure to stay in touch as we hear any kind of news and changes and things like that. So again, always appreciate your time.
Thank you for having me.